Right, good afternoon, everybody, and welcome to the first in our series of webinars that we're giving in Chambers on clinical negligence matters. We are kicking off today with an update on quantum, first of all, and on that general quantum topic, I'm going to take the living, and Kate is going to take the dead. Helen is then going to round off with a consideration of when a claimant's illegality gives rise to a defence, with the Supreme Court's latest thoughts on that very interesting subject. If you have any questions, then I'm afraid in this webinar format, it's not very practical to invite you to give them here and now. But what we undertake to do is to answer your emails, and we would encourage you to send in an email to any one of the three of us with any questions you've got arising from the content of our talks this afternoon. So as I say, I'm going to talk about a quick update on quantum in the context of the living, and no update on quantum could fail to at least mention future accommodation after Swift and Carpenter, or of Ogden 8, both of which hit us at the very beginning of this legal year. Now, I'm not going to give you a detailed talk on either of those two topics, because you have had a detailed talk, or a detailed talk about Swift is available still on our website. And that was a tour de force from Helen and from Nina Unfenk. And equally, if you look to our website, you will see a very thorough and detailed talk on the changes in Ogden 8 over its predecessor, given by Christopher Russell and Roger Harris. So I won't duplicate the very good work that's already been done, but what I will attempt to do is just give some indication of how this is working out in practice, or how I found it's been working out in practice doing my schedules and counter schedules. Swift and Carpenter, obviously dealing with the question of future accommodation claims. As I say, I'm going to just canter through how it's been working out in practical terms in schedules and counter schedules that I've been looking at since October last year. We all know, I think, the principle, which is that you discount for the term certain of the representing life expectancy by 5% a year to arrive at the value of a remainder, which would otherwise be the windfall available to the claimant's estate on death. So your discounting factor is going to be 1.05 to the negative life expectancy. The value of the reversion, if you look to your calculator, or even better, if you just have a quick squint at what used to be table 28 with what used to be published as a plus 5% discount in the days when that was thought to be potentially relevant in some of the older tables, you will see that the value of the reversion doubles approximately every 14 years. And despite what the Court of Appeal said in Swift, with at least some inflation hedging, because the remainder, of course, is an interest in property, and historically, property has been at least some hedge against inflation. And according to the actuarial expert evidence before the Court of Appeal in Swift and Carpenter, this was something that surprised me. It's apparently all free of tax. So that is potentially, one would have thought, despite the Court of Appeal describing it as 5% as a conservative figure, that is a potentially excellent investment for a property speculator compared to what other returns are available in the market. And of course, if you are a claimant and you have received your future losses using a negative 0.25 discount rate, you can effectively be investing in your own reversion by delaying the onward sale of that until you really need the cash. And further thought that claimants with longer life expectancies could at least theoretically start to invest in shorter duration reversions from those with lower life expectancies, either because that's the effect of their injury or because they've delayed cashing in their chips until towards the end of their life, and we're now getting to a period of shorter expected period before the reversion, as it were, matures, and those short duration reversions are generally regarded as being more marketable and easier to deal with. And it's worth perhaps, I just put the crosshairs on this graph on the week that the judgment in Swift and Carpenter was given. I don't know how many of you follow the yields that are available on 10-year treasuries, probably not many of you, but you may find it interesting to note that the yields fell quite dramatically starting at the beginning of 2020 and very likely connected to the whole COVID business, and reached a bottom more or less the time that Swift and Carpenter was being argued and decided, and have bounced back up really quite dramatically at the beginning part of this year. Of course, who knows whether that will continue or not. And to put this in perspective, we're still, of course, dealing with those are the returns in nominal yields, and one has to factor in the fact that there's inflation of round about 1%. So it's still a negative real yield, but it's far less negative than it was even as recently as October when Swift was decided. Short life expectancies were discussed by the Court of Appeal in Swift, and questions arose as to whether those shorter life expectancies should be treated differently. Were they special cases? The first question that arises with people trying to sort out where they are in relation to Swift and Carpenter is when you've got a short life expectancy. One can suppose that probably the Court of Appeal had in mind life expectancies of less than about 7 years, because one of the paradigm cases that was put before them involved life expectancy of 7 years. And Lord Justice Irwin referred to that paradigm and said in very qualified terms that it may be my emphasis that different considerations and arguments could, my emphasis, apply. Lord Justice Nicola Davies agreed with the reasoning and conclusions of Lord Justice Irwin without adding much on that particular topic, but Lord Justice Underhill approached it arguably slightly differently, suggesting that the arguments were different, the position will be different in short life expectancy cases. Against that, there's a clear recognition in Lord Justice Irwin's judgment that short life expectancies lead to more marketable reversionary interests. So the shorter the life expectancy, the more likely you are to attract interest from someone who would like to have 5% per year tax-free for the rest of your life. So I raised the question as to, well, really, why then should short life expectancies be any different? After all, a claimant with a 5-year life expectancy, say, would obtain about 21.7% of the additional capital costs applying Swift. That same claimant would have got only 12.6% of additional capital costs applying the old rules in Roberts and Johnston. And it's true that there were, of course, criticisms of Roberts even before we got to negative discount rates. But the fact remains that the change brought about by Swift was brought about because of changed economic circumstances, which included a negative discount rate. And that had it not been for that, then the inference is that the older system under Roberts and Johnston would otherwise be satisfactory. So claimants who've been used to, for many, many years with short life expectancies to be getting very much less than the capital required for their special accommodation are now in a better position than they were before. And as I've mentioned before, and I note here on the slide, an astutely advised claimant will have delayed sale of reversionary interest for as long as practicable in any event, because if you get your money using a negative discount rate and you're able to invest it getting plus 5% tax-free in real terms, then you will, if well advised, want to delay your sale for as long as you can, and that potentially makes all sales short life expectancies. The other thing I wanted to just raise, because we've all read Swift and seen very able talks on it, and we think we understand it perfectly, and then we look at the evidence in our particular case, and we end up scratching our heads thinking, well, how does that fit in? And there are some unanswered questions from Swift. The Swift case itself was unusually simple. She and the defendant, who she had married by the time of the trial, already had an existing home. I say the defendant. She and the defendant lived in an existing home, which she shared with her fiancé and by the time of trial, husband. But maybe, unfortunately for her, was in her sole name, although the defendant contributed 50% to the mortgage. That wasn't, as I understand from Mrs. Justice Lambert's judgment, argued in front of her that there was any kind of resulting trust or that the claimant only had a half interest in that property. There are some good descriptions of what a pleasant area the property was in Brackenbury village. And there was a lot of discussion about whether the claimant would have moved home in any event. The defendant saying that she would have had to have gone to a bigger house because she and her husband had plans for 2 or 3 children. There's a lot of discussion about whether she would either deliberately or accidentally end up with more children, with 2, 3, or even more children, and that a larger house would therefore have been required. And again, it does not appear that the claimant argued that if she did move to a bigger house, that would be a house in which she would have a half interest shared with her husband. Perhaps that wasn't an argument available on the facts, but Mrs. Justice Lambert determined that she needed a home costing £900,000 more than the home she already had, and therefore the maths was really terribly simple. But you will probably find when you do your cases that sometimes the expert evidence, rather inconveniently, doesn't lead one to such nice, clear, simple arithmetic. And for example, it's not at all uncommon to have evidence to the effect that, this is just meant to be an example, perhaps the claimant would have lived in his or her parents' home cost-free to the age of 20, early 20s would have lived in a rented flat all on his own, late 20s would have lived in a rented flat with a partner, 30s would have lived in an owner-occupied flat with their partner, maybe in middle age would have lived in an owner-occupied house, and maybe in old age would have lived in a care home. And you'll see at once that that's a far more complex set of circumstances than was dealt with in the Swift and Carpenter decision. And there are no clear answers as to what we do from Swift and Carpenter, but I suggest the guidance that is going to steer us to what is likely to be the correct answer is to keep the justification and reasoning for the decision in Swift very firmly in mind, and to always ask your question, what is the reversionary interest that the claimant's estate will theoretically, or that the claimant can theoretically sell that represents the current value of the windfall that would otherwise be passing to the claimant's estate on death. And that suggests looking at the home that the claimant would have ended up in at the time that he is predicted to die. But I think there may be an exception even to that proposition, in that I suspect strongly that we will ignore the fact that about a third of adults end up in and end their lives in care homes. There was some discussion in Swift as to what would happen if the claimant's actual projected course would end up in a care home. And it does seem from the judgments that in the interests of pragmatism, this could be disregarded. Lord Justice Underhill at paragraph 229 disagreed there was an element of disagreement anyway between himself and Lord Justice Irwin as to how likely it was that injured claimants would end up in care homes. But the difference in view didn't matter, because Lord Justice Underhill made it plain that it would have a small effect, and it was best not to complicate matters and to simply disregard it. So if one takes my examples, if the claimant dies before the age of 20, then we've got the simplest possible case with the reversion based upon the full costs of the required accommodation, because uninjured at the age of 20, he would have been living without his own property. So that's simple. Take it up to age 25, say, I see no reason in principle why the saved rent would not be deducted from the future accommodation claim. So you work out what the special accommodation costs, you subtract the current value of the reversionary interest that falls due on death, and then you subtract from that figure the rent that has been saved up until that age. Get to age 30, same principles apply, but there is strong argument that if the rented flat would have been shared with the partner, that you take 50% of the rent, because that is the amount that the claimant in the but for the injury world would have been paying. At age 40, special accommodation less half the value of the flat as it's shared with a partner, and at 50, special accommodation less half the value of the house, and so on. All of those are cumulative reductions, and in the case of rent saved, would require the appropriate split in multipliers. But the principle to bear in mind is that the deduction under Swift and Carpenter will be that which is the current value of the reversion that would otherwise be a windfall benefit for the estate. Impact, what if the house is purchased 2 years pre-trial? Well, then you do the same calculations, but they obviously become past special losses, and I see no reason in principle why a claimant would not be entitled to get interest on the special cost less the value of the reversion. Life expectancy, well, take an example. What if the claimant's life expectancy has been reduced by the tortious event from, say, 85 down to 29? Then I suggest you take the accommodation he would have had at 29 rather than 85, and the claimant gets the special accommodation less the half value of the flat in the circumstances of this example, suitably discounted, and then also giving credit for the rent that he saved at age 20 to 25, as an example, or save rent from 20 to 29, which is what I mean by dealing with the deductions cumulatively. I think that's all sufficient probably for me to say about Swift and Carpenter in practice. If you need a refresher on the principles in Swift and Carpenter, as I say, we have a very good talk on our website. So I'll deal now swiftly with Ogden 8. I think, have to start speeding up. There are some interesting changes in Ogden 8, which again have been dealt with in some detail elsewhere. But the most noticeable one is that, notwithstanding the fact that all the statistics come from pre-COVID times, the note from the Ogden introduction, which is from the chairman, William Latimer Sayer, QC, and he indicates that at the time of writing, the UK is under lockdown, and he thinks that there's no doubt that the impact of COVID-19 on life expectancy, employment prospects, and the economy will need to be considered in future editions of these tables. I'm not absolutely convinced about that, because we can see from this long-term chart in relation to life expectancies that the effect of disasters like the Spanish flu, like COVID-19, are really temporary blips in a very constant upward march in life expectancy over the past 150 or more years. It's striking that life expectancy at birth in this country has gone up it's gone up a decade every 50 years. If you're born 50 years later, you expect to live 10 years longer, which is quite extraordinary. And the very clear blip between 1915 and 1925, downward dip. One might think, well, maybe that's due to the First World War. It clearly isn't. It's due to the Spanish flu. And that can be demonstrated when you look at the impact on persons of different ages, and you can see how profoundly, wholly unlike COVID-19, the Spanish flu affected younger generations, younger people, far more than it affected older people. So will there really be any change in future editions due to COVID-19, or will COVID-19 be by then part of history? A quick word about when we can depart from Ogden. The Working Party are not keen on departures from Ogden. There's this quote from their general guidance. Courts are generally reluctant to admit expert evidence to argue for different life expectancy solely on the basis of lifestyle factors, since the average in the tables includes smokers, non-smokers, teetotalers, etc., all those who might have diminished life expectancies. That is clear from some cases. Dodds and Arif, which was just prior to Ogden 8, and Queen's Bench Master Davison said no to an application to produce statistical evidence relating to high blood pressure, raised cholesterol, and so on. And that quote saying no was expressly picked up and endorsed by Mr. Justice Jay in the decision of Chaplin and Pistol, although Mr. Justice Jay was extremely complimentary to Benjamin Brown of these chambers, who was arguing that there could be or should be some admission of statistical evidence from Professor Strauss in a severe traumatic brain injury case. They are equally, the Ogden Working Party, less than keen on departures from tables A to D, being the factors that are applied to loss of earnings depending upon whether there's disability or not. It's interesting that Mrs. Justice Lambert in the Swift and Carpenter decision followed Connor and Bradman and made such an adjustment on the basis that the claimant in that case was good at her work and committed and capable. But the Ogden party are not keen. They say where a departure is considered appropriate, it could be either direction, it should normally be modest, and are not keen on the degree of adjustment made by Mrs. Justice Lambert following the case of Connor and Bradman. With those parting words from the Ogden Working Party and their exhortations for us to stick to what they have advised us is the correct approach, I hand over to Kate for a quantum update in cases involving fatal claims.
Thank you, Martin. Good afternoon, everyone. I'm going to talk about a few recent developments in Fatal Accident Act quantum, including the decisions in Young and Downey, Greater Manchester Fire and Rescue Services, and Verveers, and Witham and Steve Hill. Before we move to look at those cases, I wanted to flag two recent developments in relation to the bereavement award payable under Section 1A of the Fatal Accidents Act. First of all, just a reminder that the award for bereavement and fatal accident claims has been updated from £12,980 to £15,120. This applies only to causes of action occurring on or after the 1st of May 2020, so is unlikely to have had much practical effect yet. Secondly, the bereavement award is now payable to the cohabiting partner of the deceased, as well as to their wife, husband, civil partner, or parents in appropriate circumstances. Cohabiting partner has been defined in subsection 2A as any person living with the deceased for 2 years before the date of death, as well as at the date of death, and was living for the whole of that period as the wife, husband, or civil partner of the deceased. So those are the two recent developments to the Act itself. I'll now turn to look at those 3 decisions I mentioned at the outset and the impact that they might have on the recovery of damages in the future. So first of all, Young and Downey, which was a High Court case last year. In Young and Downey, the claimant brought a claim in respect of the death of her father in an IRA bomb attack in 1982. She was aged only 4 at the time. The claim came about after the defendant was finally arrested in 2013 when he was travelling to Gatwick Airport. In 2019, Mrs. Justice Yip held that the claimant had established that the defendant was responsible as joint tortfeasor for the unlawful killing of her father. Last year, the matter came before Mr. Justice Martin Spencer for the quantification of the damages. The claimant brought a claim for her own psychiatric harm, as well as a claim on behalf of the dependents, and a small claim on behalf of the deceased's estate in respect to the short period between the detonation of the bomb and his sad death. The claimant also sought to recover exemplary damages, and she stated very openly that this was to achieve vindication for the attack when the criminal case had failed. The defendant was not represented and didn't take any active role in the proceedings. The claimant's claims for her own psychiatric injury and for the exemplary damages both failed. Then approximately £2,000 was awarded for the short period of pain and suffering before the deceased's death. The court was then faced with a much bigger task of valuing the claim for dependency. At the time of his death, the claimant's father was a 19-year-old ambitious young soldier. He joined the army in the rank of private, aged 16, and had already been promoted to Lance Corporal by the time he died, aged 19. The judge found that he needed therefore to consider the deceased's career within the army and then as a civilian after he would have left it. It was accepted by the claimant that the calculation should be based on loss of a chance. And accordingly, the judge looked at the likelihood of the deceased achieving various different career milestones. The claimant relied on an employment report and a forensic accountancy report, both of which were naturally uncontroverted, given the defendant's decision not to play a role in proceedings. The judge then made findings as set out on the slide before you. For instance, the judge found that the deceased had a 75% chance of achieving 22 years service in the army, and he accepted the employment expert's opinion on likely promotions and accompanying salary. The judge then used the additional claim method to calculate the total value of the dependency claim. And as you'll see on the slide before you, in effect, the judge found that it was certain that the deceased would complete 9 years service in the army and then go on to achieve median civilian earnings after that. That was valued in the sum of about £470,000, and that was the base award. To that base award, further sums were added to reflect the probability of that additional scenario actually happening. So, for example, there was a 95% chance that the deceased would have spent 12 years in the army. So the base award, as you can see from the calculation, was increased by £23,650 to reflect the chance of that happening. And as you see, there was then a 75% chance of 22 years in the army, and so that was added on, and then a 50% chance of 22 years service, and then upper quartile civilian earnings afterwards. So that additional element was added on as well. And you can see from the slide that the total came to £713,457. Young is a useful case as it sets out simply and clearly the approach that a court may take where the deceased died young with a long career ahead of them, which can be carefully mapped out stage by stage. Helpfully for defendants, it's further support for the principle that in such a case, damages for additional earnings at a higher rate or in a more senior role should be on the basis of loss of a chance. rather than on the basis that the scenario would, on the balance of probabilities, have actually occurred. In this case, there was clearly very good evidence that the claimant would have remained, that the deceased would have remained in the army for the full 22 years service. But in a different case, the prospects might be completely different and say there might be only a 20% chance of attaining a particularly senior role. The only caveat is that it should be remembered that these cases are not necessarily quite this clear and straightforward in practice. What the judge obviously didn't have to do here was either resolve competing approaches to the calculation or competing expert evidence, given that the defendant didn't attend. That's Young and Downey. If I turn next to talk about Greater Manchester Fire and Rescue Services and VEVAs. In VEVAs, the claimant brought a claim in respect to the death of her son, who was a firefighter killed during the course of his employment. The question arose as to whether the claimant was entitled to recover the costs of preparing for and attending the inquest. Those costs were substantial. They were about £141,000 out of a total cost bill of about £334,000. The Deputy District Judge held that the costs of the inquest were in principle recoverable, and the defendant appealed. The procedural background, which, as I'm sure you'll appreciate, is quite important in this case, was as follows. First of all, solicitors for the defendant wrote to solicitors for the claimant stating, "Our clients are not in a position to consider an admission of liability, but are willing to compensate the estate and dependents for any loss which they may prove to be attributable to the incident, together with their reasonable costs. It is not our client's intention to allege contributory negligence or to seek any reduction of damages in this regard. We confirm that our clients will deal with the claims on a full basis." The claimant replied, inviting the defendant to admit liability formally, because the intention to pay compensation could, of course, be withdrawn at any stage. It was confirmed that the claimant would continue to prepare for the inquest until such time as liability was admitted or the claim settled. The defendant responded, setting out that there was no need to prepare a letter of claim, and that obviously our earlier correspondence makes it plain that the claims by the dependents and the estate will be met without reduction. The claimant responded, stating that they were happy not to send a letter of claim based on the defendant's offer to deal with any claim for compensation without reduction. Thereafter, the inquest took place, and the claimant attended with full legal representation. The particulars pleaded reliance on the defendant's letter referencing compensation. The defence admitted liability and the claim was settled in the sum of £80,000. It was at this point that the defendant disputed the costs of the inquest, stating that it had admitted culpability in its first letter, which had then been pleaded and relied on in the particulars of claim by the claimant. On the defendant's case, in this scenario, the costs of the inquest were not recoverable. On appeal, His Honour Judge Pearce considered the judge carefully and summarised the law as follows. Inquest costs are recoverable, provided that they're incidental to the claim, but they won't be recoverable if liability is no longer in dispute. In making this decision, the court must look at all the circumstances of the case. If there has been an admission, obviously liability won't be in dispute. But the judge should look very carefully at anything less than an unqualified admission to see whether the defendant could resile from its position. The judge may find that a failure to make an unqualified admission justified the conclusion that the defendant might resile from the admission, and therefore costs of the inquest could be said to be incidental to the claim. If so, the mere fact that there are other reasons the family wish to attend the inquest does not mean that costs are not recoverable. It is enough that attendance for the purposes of securing evidence was a material purpose. Applying these guidelines to the case, the judge dismissed the defendant's appeal. He found that the defendant's position in the pre-action correspondence had been equivocal. The judge also went on to say that had the defendant not conceded liability in its defence, it might have been open to the claimant to argue that this change of position amounted to an abusive process of the kind considered in Stoke-on-Trent City Council, Whalley, and Gale and Superdrug. Accordingly, Vivas serves as a useful reminder of the benefits of making careful, timely, and clear admissions at an early stage of proceedings in appropriate cases. In this case, in terms of inquest costs at least, nothing was achieved by indicating an intention to pay compensation without a formal admission. The judge's reference to possible abuse of process arguments shows that the non-admission might not have even protected the defendant's position. Vivas should also serve as a reminder that pre-action correspondence should be approached with the same care as the rest of the case. It may well find its way before the court should these kinds of issues arise. One further point to make is that the judge hinted that the defendant had an argument available to it which should have failed to deploy. That was that the claimant had, in effect, acquiesced to the position adopted by the defendant by stating that they were happy not to send a letter of claim based on the defendant's offer to deal with any claim for compensation without reduction. In those circumstances, said the judge, the defendant could have raised the argument that but for the claimant's acquiescence in the communications, it would have made a formal admission, and the court could then have taken the view that the costs of attending the inquest were not reasonably incurred because they could have been avoided. In this case, that argument had not been run, so the judge didn't offer a concluded view on it. But nevertheless, this part of the decision may provide defendants with a means to attack an application which includes inquest costs, where liability has not been unequivocally admitted. I stress the word may in that sentence, as I think there would have to be a very particular set of facts for that argument to succeed. Finally, turning to Witham and Steve Hill. In Witham, the question for the court was, could the claimant recover damages under Section 3 of the Act as a dependent upon the deceased remaining at home to provide childcare and domestic services, which was done so that she, the claimant, could go to work? If so, should the dependency be valued as replacement care or the claimant's loss of earnings and pension loss? The claimant's husband died aged 55 as a result of mesothelioma. Liability was admitted and the assessment of damages came before Anthony MIRZA QC, sitting as a Deputy High Court judge. The claimant and the deceased did not have any biological children, but from 2015 started fostering 2 children who were brother and sister. Both children had diagnoses of disorders on the autistic spectrum and required additional care as a result. Children are referred to in the decision as A and B. The judge found that once A and B had been placed semi-permanently with the couple, they decided that the deceased would stop work and the claimant would resume her nursing career, leaving the deceased as the main carer for the children. The defendant argued that since A and B, as foster children, had no claim under the Fatal Accidents Act, their claim had simply been relabelled as the claimant's own services dependency claim, which in reality it was not. It was, said the defendant, in substance, A and B's dependency claim. The defendant relied on the case of Rupa Singh and West Hertfordshire Hospitals NHS Trust, where the claimant had claimed for the reduction of her own earnings resulting from her move to Sri Lanka to access the support of her family to replace the childcare that her husband, who had died, had previously provided. Her claim was rejected because the Children's Services dependency claim had already settled, and accordingly, the judge held there was nothing left to value. In Witham, the judge disagreed with the defendant and found that the dependency was in fact the claimant's dependency and not that of the children. The starting point, said the judge, as set out in O'Loughlin and Cape distributions, was that there was no prescriptive method by which such damage was to be identified or calculated, apart from the principle that some damage capable of being quantified in money terms must be established. Once the deceased had sustained his serious illness, said the judge, it became necessary for the primary care that he carried out for A and B to be replaced by the claimant. Although A and B were effectively dependent, the judge considered that they in fact suffered no loss, as the claimant simply replaced the deceased in providing their care. That was, he said, the reality of the situation. The claimant had lost her full-time career as a result of the deceased's death. She was dependent upon him as principal carer for A and B to enable her to pursue a career for the benefit of the whole family. The judge then stated it was effectively the family's loss of the deceased acting as principal carer and the family's finances decreasing by the measure of the claimant's lost earnings. But that doesn't detract from the fact that it is the claimant's loss. The judge distinguished Rupa Singh on the basis that the children in that case were able to claim in their own right as dependents, and that claim had already been compromised. The claimant's claimant, Rupa Singh, was not an attempt using loss of earnings as a proxy measure to value the loss of the deceased services, but a broader endeavour based on the claimant's loss of her career. Having found that dependency was the claimant's dependency, the judge turned to the question of how it should be valued. He found that replacement care was the appropriate measure of loss, not lost earnings, the claimant's lost earnings. The judge also awarded the full commercial cost of the services without any reduction. Witham demonstrates that the court may well be prepared to think creatively when faced with the question of how to compensate claimants. The judge was prepared to find that the principal no Lachlan, that the court should examine the particular factual circumstances of the case, was sufficiently broad to encompass care given to non-dependents, where the dependent could be said to be the one to have truly suffered the loss. Moreover, Witham is a further application of the court's approach to the quantification of services dependency claims following Nower and Ministry of Justice. That is, that services that have been lost should be valued by reference to commercial rates, without any reduction to take account of the fact that the care might have been provided gratuitously. However, we should be slightly careful about drawing too many conclusions from Witham just yet, as I understand that there is an appeal outstanding. Thank you very much. I'm now going to hand over to Helen Wolstenholme, and please do email us if you have any questions. As Martin said, our email addresses will be on the final slide.
Thank you, Kate. Thank you, Martin, and good afternoon, everyone. We're going to leave quantum issues now and move on to a very different topic, the defence of illegality. There's been a spate of fascinating Supreme Court authorities in this field in the last few years, culminating in a judgment in October 2020 in the case of Henderson and Dorset Healthcare. Now, before I come on to the facts of that case in detail, I think it's worth just reminding ourselves of the basics in terms of illegality. It's a defence that doesn't come up very often, and you'd be forgiven if the intricacies of it aren't at the forefront of your mind on this Thursday afternoon. So first of all, the underlying rationale for the defence of illegality is that it would be contrary to the public interest to enforce a claim if to do so would be harmful for the integrity of the legal system. So what that means really is that the legal system must be consistent. A person shouldn't be able to recover compensation for loss which they have suffered as a consequence of their own criminal act. So if, say, a person has lost earnings because they've been sent to prison and can't work, they shouldn't be able to recover damages in respect of that loss of earnings in any civil claim. In such a case, it's the law which, as a matter of penal policy, causes that damage, that loss of earnings, and it would be inconsistent for the law to require that a person be compensated for that damage. So, as Lord Hughes put it in the case of Hunger and Allen, the law cannot give with one hand which it takes with another, nor condone when facing right what it condemns when facing left. The second point is that it's a complete defence, the burden of proof lying, of course, on the defendant to establish it. So it's not like contributory negligence where damages are apportioned. The judge can't say, well, the claim arises out of the claimant's illegal act, but to be fair, it wasn't that serious and the defendant's conduct was even more appalling, so I'll only award 50% of the damages. If it operates to defeat the claim in its entirety. The third point is that it operates across the entire legal spectrum. Not just tort claims, but all civil claims may be defeated by a defence of illegality. And the final basic point to emphasise, And the point which gives rise to the challenges in this area is that the claimant's wrongdoing or illegal activity will not always affect their entitlement to a remedy. So standing back, of course, this is obvious. We're all familiar with cases where a claimant may have been driving over the speed limit or may have been driving whilst intoxicated at the time of an accident. But that doesn't mean that they will always be unable to recover damages against a negligent driver. The key question then is, when will a claimant's criminal conduct bar recovery? That's what we need to know in order to advise our clients. Now, in the past, it's not been an easy question to answer. There has been divided judicial opinion at the highest level regarding whether the illegality defence should rest on a tight rule-based approach, which focused on whether the claimant would have to plead or rely on the illegality in order to establish the claim, so removing any discretion from the court, or whether a wide range of factors should be taken into account with competing policy arguments weighed by the court in each case. Helpfully, though, the law was clarified by the Supreme Court in the case of PATEL and MIRZA back in 2017, and it's been further clarified by the Supreme Court in the case of Henderson and Dorset Healthcare. So, turning to PATEL and MIRZA first of all, this involved a claim in restitution for unjust enrichment. The claimant had paid the defendant £620,000 for the purpose of investing in RBS shares using insider information, which the defendant expected to obtain in advance of an anticipated government announcement. Well, in the event, no government announcement was made, no insider information was provided, and the money wasn't invested. But the defendant refused to pay back the money to the claimant, and the claimant brought a claim for unjust enrichment. The trial judge, who referred to the illegality of the arrangements as the proverbial elephant in the room, he also said that counsel for the claimant had suggested that really it was no more than an insignificant mouse. But really, effectively, on the trial judge's suggestion, the defendant for the first time pleaded the defence of illegality. The illegality, of course, being that the agreement by the men was a conspiracy to commit an offence of insider dealing, contrary to Section 52 of the CJA 1993. Now, perhaps, surprise, surprise, at first instance, the judge having suggested the defence, the judge dismissed the claim. But the Court of Appeal allowed the claimant's appeal, and the Supreme Court upheld the decision of the Court of Appeal. In the Supreme Court, a panel of 9 justices sat. It was agreed by all 9 justices that the defence of illegality failed and the claim should succeed. This was essentially on the basis that an order for restitution of the money paid by the claimant to the defendant would merely return the parties to their previous position before the conclusion of the illegal contract, and so would prevent the defendant gaining by unjust enrichment. But there was a difference in opinion as to the correct approach to the illegality defence. It was a 6-3 split. The majority took the view that a wide range of factors should be taken into account. The minority considered that the reliance-based approach should be applied, so focusing on whether the claimant would have to plead or rely upon the illegal act in order to establish the claim. The minority considered that a broader approach would confer too much discretion on the courts, requiring value judgments to be made about the respective claims of public interest and those of the parties. Anyway, what did that policy-based approach involve? The majority held that when considering an illegality defence, the court should focus on what was described as a trio of necessary considerations. These were set out by Lord Tolson as follows. First of all, consider the underlying purpose of the prohibition which has been transgressed and whether that purpose will be enhanced by denial of the claim. Secondly, consider the possible effect on relevant public policies. Third, consider whether denial of the claim would be a proportionate response to the illegality, bearing in mind that punishment is a matter for the criminal courts. The focus here is on ensuring that a claimant isn't treated unfairly in comparison with their blameworthiness. Lord Tolson refused to lay down a prescriptive list of factors which may be relevant to proportionality, but did state that potentially relevant factors included the seriousness of the conduct, its centrality to the contract, whether it was intentional, and whether there was marked disparity in the parties' respective culpability. Now, I've highlighted on the slide the words "whether it was intentional," because this was one of the key points focused upon in Henderson, which I'll turn to now. Now, the facts of Henderson are tragic and memorable. The claimant, who had a history of schizophrenia with paranoia, killed her mother by stabbing her during a psychotic episode. At the time of the killing, she was under the care of a community mental health team managed and operated by the defendant NHS Trust. The claimant pleaded guilty to manslaughter on the ground of diminished responsibility, and she was detained in a secure hospital pursuant to a hospital order with restrictions made under sections 37 and 41 of the Mental Health Act. It's worth saying here that she was assessed before the criminal trial by 2 forensic psychiatrists regarding the defence of insanity and whether that was established. And both of those psychiatrists concluded that it hadn't been. They agreed that although the claimant was psychotic at the time and that her mental functioning and her ability to act rationally were impaired, she knew what she was doing was morally and legally wrong. The claimant brought an action in negligence against the trust, contending that she wouldn't have killed her mother if it hadn't been for the trust's breach of duty in failing to return her to hospital when her condition deteriorated. She sought damages for loss of liberty and loss of immunity consequent on her detention, damages for having developed a depressive illness, and damages for having lost her share in her mother's estate pursuant to the Forfeiture Act. The trust admitted breach of duty, but contended that since the damages claimed were the consequence of the sentence imposed by the criminal court and/or the criminal act of manslaughter, they were irrecoverable on the grounds of illegality and public policy. Now, the claim failed at first instance and in the Court of Appeal. Both courts held that the facts were materially identical to the case of Grey and Thames Trains, which had been considered by the House of Lords 8 years before the Supreme Court considered the case of PATEL. Now, the facts in Grey were similarly tragic and memorable. In that case, the claimant, Mr. Grey, was a passenger on a train involved in the Ladbroke Grove train crash, as a result of which he suffered PTSD. Whilst suffering from that disorder, the PTSD, he killed a total stranger. He pleaded guilty to manslaughter on the grounds of diminished responsibility, and he, like Ms. Henderson, was ordered to be detained in hospital under sections 37 and 41 of the 1983 Act. Mr. Grey brought an action in negligence against the train operator and the company responsible for the rail infrastructure, who were responsible for the Ladbroke Grove crash, and claimed damages in respect of his detention, his loss of earnings during his prison sentence, general damages for his feelings of guilt and remorse about the killing, and also an indemnity against claims which might be brought by the dependents of the deceased. The defendants in Grey admitted negligence, but claimed that the claim should fail on the grounds of illegality or public policy, and the House of Lords agreed with them. They held that damages for losses which resulted from a sentence imposed for a criminal offence or from an intentional criminal act for which the claimant had been responsible were irrecoverable on public policy grounds. Now, it's obvious then to see why in Henderson, the court at first instance and the Court of Appeal found the case to be analogous to Grey and to be bound by it. But the claimant appealed to the Supreme Court on the grounds that Grey could be distinguished or should be departed from in light of the Supreme Court judgment in PATEL, particularly where a claimant has no significant personal responsibility for the Criminal Act, or there is no particular penal element to the sentence imposed. These arguments weren't successful. The Supreme Court held that Gray couldn't be distinguished and shouldn't be departed from in light of PATEL. So let's just consider the judgment of the Supreme Court in a bit more detail. First, unlike in PATEL, it was a 7-member panel, and there was a single judgment given by Lord Hamlin. The first point to note is that PATEL's trio of necessary considerations was held to apply across the panoply of civil law to the defence of illegality. So not just to unjust enrichment, which was of course the index issue in PATEL. Secondly, the trio of necessary considerations guidance in PATEL shouldn't be considered groundbreaking. It was derived from pre-existing case law. As Hamlin put it, PATEL didn't represent year zero in the case of illegality. He said, it's important not to undermine the role of precedent and the certainty which it promotes. So earlier decisions on the illegality defence remain of precedential value unless it can be shown that they are incompatible with the PATEL approach. Thirdly, since Gray and Thames Trains had been decided by reference to public policy considerations, namely the need to avoid inconsistency between the criminal and the civil law, and the need to avoid undermining public confidence in the law, it was compatible with the trio of necessary considerations approach. So Gray couldn't be distinguished and it shouldn't be departed from. And also, since Gray involved manslaughter on the grounds of diminished responsibility and had been decided by reference to the fact that Mr. Gray had been found to be criminally responsible, rather than by reference to his degree of personal responsibility, Henderson couldn't be distinguished. Neither claimant, Henderson or Gray, bore significant personal responsibility, but neither had satisfied the insanity defence. And then finally, applying the PATEL approach, the claim should fail. So in particular, it should fail because PATEL necessary consideration 1, the underlying purpose of the prohibition which is being transgressed. Well, that was clear here. This was the public interest in deterring, protecting the public from, and condemning unlawful killing. Pretty obvious. PATEL necessary consideration 2, any other relevant public policy on which the claim or its denial may have an impact. Well, here, these included the need to avoid inconsistency between the criminal and the civil law. And this consideration was heightened by the very close connection between the claimant's claim and the illegality. The crime, the manslaughter, was the immediate and effective cause of all of the losses she claimed. Also, the need to maintain public confidence in the law. The significance of this was again heightened by the gravity of the claimant's wrongdoing and the public interest in the proper allocation of NHS resources. It was noted that NHS funding is a matter of significant public interest and importance. And if recovery had been permitted, funds would be taken from the NHS budget to compensate the claimant for the consequences of her criminal conviction for manslaughter. Third, PATEL necessary consideration, whether denial of the claim would be a proportionate response. Well, it was held it would be. This was a very serious offence. The claimant knew that what she was doing at the time was morally and legally wrong. The conduct was central to all of the heads of loss claimed. There was an intent to kill or do GBH, even if there was no significant personal responsibility. And there was no marked disparity in the claimant's favour in the parties' respective wrongdoing here. The defendant didn't do nothing in response to the claimant's mental health collapse. It just didn't act quickly enough. So finally, what conclusions can be drawn? Well, first of all, the trio of considerations approach applies across all civil claims, but importantly, judicial discretion has been constrained by Henderson. Earlier case law remains highly relevant. So where the facts of a case are very similar to one which was decided pre-PATEL, it seems likely that the same approach will be followed. Particularly important factors are the preservation of the integrity of the legal system. So that must be especially relevant where a claimant has been convicted of an offence and punished. So that will be different from the PATEL situation. The prevention of profiting from wrongdoing, the closeness of the connection between the claim and the illegal act. So is the illegality part of the backdrop, or is it central to what happened? So think back to that example that I gave at the start of the drunk driver who is hit by a negligently driven vehicle. In that kind of case, the intoxication might be considered part of the backdrop rather than central to the accident and to the claim. And then finally, the seriousness of the claimant's conduct. The policy-based test espoused in PATEL doesn't necessarily require the issue of proportionality to be considered. So that's the third consideration in PATEL. And that was rather downplayed by the Supreme Court in Henderson. It was said that if the balance of policy factors points against denial of the claim, it's unnecessary to address the issue of disproportionality. And Lord Hamlin described PATEL as adopting a disproportionality check rather than a proportionality requirement. But where it is necessary to inquire as to proportionality, the centrality of the offending and the closeness of the causal connection will be important considerations. So that's it from us. Thank you very much indeed for attending today. We hope that you found it very useful. If you have any questions about any of the points that we've discussed, please do email us. Our respective email addresses should be available to you on the website, and they are there on that slide. Thank you very much.